Principal sir and today's speaker Mr. Vijay Kumar Makyam. A warm welcome to you all for the session. Today we have gathered here to conduct a seminar on awareness of intellectual property rights and management of startups. I take this privilege to invite our principal sir Dr. M.B. Raju Garu. Please adore the dais sir. Now I would like to invite Director of PEC, Professor R.K. Mishra Garu. Sir, please come on to the dais. It's time to invite today's resource person, Mr. Vijay Kumar Garu, Technical Member of Intellectual Property Rights and Indian Patents. We would begin the session with the lighting of lamp. I request the dignitaries to join for the lamp lighting. Please accommodate your seats. Thank you for the dignitaries to joining for the lamp lighting. Now I request our principal sir to address the gathering.
Good afternoon, respected today's chief guest and resource person, Mr. Vijay Kumar Garu from NIPAM organization, and our respected Director Garu, Dr. Mishra Garu, and our Dr. Ramana Garu, and all heads of the departments and faculties and students. A warm welcome you all for this today's seminar on intellectual property rights. As you know about the IPR, how many actually it is there in your curriculum, I think. Will you agree or not? It is there, I think, in your 3.1 or 2.2 maybe. 3.1 or 3.2. Now you see, this is a very important aspect for registering your own inventions. You see, this IPR is very important. Very important. Why? Because you see, you can protect your own inventions. You can market your own inventions. You can commercialize your own inventions. So like so on, there are so many advantages once you register or protect your own inventions. In the future, you may have so many advantages, and moreover, it can be known to the path to invent some other new things for the future upcoming students. That's how the inventions will take place actually. Now coming to this program, you see already this IPR is very important in our new education policy 2020. And one more important point is, you see, we are going to conduct the international conference in ISB on 15th and 16th of this month. So in IPR, in new education policy, they have the more focus. They have the more focus on liberal arts. You see why? Because the liberal arts are very, very important. Why? Because everybody nowadays, most of the people, they are becoming engineering graduates only. Without moral and without ethical values, it is useless. So that's why our liberal arts, our new education policy is more focusing on the liberal arts. So, dear students, we are giving the chances for the top 10 students, maximum top 10 students in each class or each department wise. Anyhow, your department HODs are going to give the information. So they are going to share the link also. So for that link you have to register and you have to attend that program without fail. Thank you, Anand.
Thank you, sir. Thank you for your valuable welcome address. Now I request the Director of PEC, Professor R.K. Mishra Garu, to share a few words on this occasion.
Thank you, Priyanka. Let me also welcome our respected guest, Vijayji, our respected Principal Raju Garu, respected Ramnaji, respected colleagues from the faculty, and all the friends. This is very, very important conference. You have seen, we always talk of US, but we don't talk of India, we talk of China, but we talk less about India. So you find that the American economy is based only on IPRs. Today America is America because America believes in IPRs, they invent, they register, they take royalty. In our country, when we talk of technology, most of the technology has come on which we have to pay royalty. And this amount of royalty is not small. This is a very, very huge amount. And therefore, I think all of you who are doing engineering, please take a vote that each one of you will all at least invent one IPR will get registered. Our country, never thought of registering, and Americans, some people they wanted to register NEEM also as their IPR. Turmeric, I think, which we do too much of turmeric in Telangana, they wanted to register in US in their name. In Tulsi also, they want to register in their name. And therefore, I think high time has come that we should know about our wealth. We only believe in property, but we don't believe in intellectual property. Now, as a part of new education policy, we have to have sustainable education. Sustainable education will emphasize more on IPRs than what is known as manufacturing and these things now. And therefore, I think all of you should try to see what is new that you can do. If you have to increase our GDP, IPRs can play very, very big role. And you have been seeing that all IITs, all NITs, all of them, they are now trying to prove that they are leaders in the field of engineering education because they have more IPRs, I think, to their credit. In our PEC also, I understand that some of us have IPRs, but we don't have many patents, I think. Patents, copyrights, IPRs, they are very significant, very important. And therefore, I would say that, as Principal Sahab has just narrated, as a part of new education policy, let there be a greater emphasis, I think, in each course that you come across, that you think, see, where you can have your own IPR. So IPR will take us to, will make us a very great economy, which we are not. You see now, US, the GDP of US is $30 trillion. GDP of China is $18 trillion, GDP of India is just $3 trillion. That means we are 1/10 of America and we are 1/6 of China. But this 1/10 and 1/6 has been because we are very low in IPR. So I take this opportunity again of welcoming Vijay Kumarji, and also I would like to thank Priyanada for arranging this very significant event at PEC. I hope you will hear very passionately and will take it to your mind and heart and will try to see whether in your life you can have one or two, IPRs and patents in your life. Thank you.
Thank you, sir. Thank you for your wonderful speech. Now it's time to invite our academic advisor, Dr. D.V. Ramana sir, to share few words regarding the seminar.
Good afternoon, my dear friends, and respected Professor Mishra sir and Principal sir and the expert Vijay Kumar garu. See here, you know how you are protecting your property. These are all physical property which you are taking care of it. Now, I think I am confident that India is having a huge startups are going to initiate. In that, I think from PEC, I am expecting at least within 10 years, some people are going to start a company. They want to know what are the things you have to observe to initiate a startup company. If you are very much interested to provide the employability to students or campus placement for your company, I think Vijay Kumar sir is going to deliver such a beautiful points to you all, which are very much useful to you. If you are having hunger to create a company, what are the things are needed? What are the things to be protected? And what are the things of ideation has to generate? Those things are going to deliver lecture on in this session. So my dear friends, listen carefully. Don't be an employee. Please understand. Youngsters, don't be an employee. Become an employer and give jobs to the people. That is the thing next generation. Okay? So best of luck. Please listen carefully. Note down the points, and I am confident you must initiate a company. Okay? With that intention, I think PEC is creating a opportunity for you to start a company on yourself. Whether it's an IT company or maybe any other company. These are the things that are mandatory. So please listen carefully. Don't miss the session. Best of luck to you all.
Thank you, Ramana sir. Before starting the session, I take this privilege to introduce today's resource person, Mr. Vijay Kumar garu. Sir has completed postgraduate in law with specialization in intellectual property rights and Master of Science in Information Technology. Sir is practicing IPR attorney. He enrolled with the Karnataka Bar in the year 2005. Sir is also a registered patent and trademark agent for Indian Patent and Trademark Office. Sir also works as guest faculty at NIMSME, National Institute of Micro, Small and Medium Enterprises, Hyderabad, and NIPER, National Institute of Pharmaceutical Education and Research, Hyderabad. And he is also a resource person for University College of Law, Osmania University, JNU, Hyderabad, JNU, Kakinada, and Ministry of Human Resource Department and Ministry of MSME. Sir is in charge for registration of copyrights and trademarks, drafting, filing patent applications, and processing them in India, as well as coordinating filing and prosecution at USPTO, European Patent Office, etc. Sir is a member of INTA, International Trademark Association, and AIPPI Anti-Counterfeit Committee member for the year 2016 to 17. A warm welcome to the campus, sir. Now it's time to hand over the session to today's speaker. I request you to take over the session, sir. Thank you.
Ravi, ఈ chairs తీసేసి డీప్ అయి ఉంచు.
Good afternoon, everyone. No voice. On చేశారు అందరూ. Have everyone everybody had their lunch or not? Yes? No. I'm hearing some no's. Can you give me a good afternoon by bigger voice? Good afternoon. Actually, I don't require mic because generally a lawyer talks, he'll talk loud, right? So if you are able to hear me out, I want to discard the mic. Yes, no? Are you able to hear me now? No, yes. Record होगा. I think we have technical problem also. We need this recording to be done. Okay. Before I begin the session, I would ask you one question. How many of you own properties? How many of you own property? Just raise your hand, whoever has property, just raise your hand. No income tax people are here, so don't bother about it. How many of you have properties? Yes, no? There are 1, 2 hands. Rest of all don't have any properties. Then definitely you don't know the meaning of the property. If you are not raising your hands, all of you, you don't know the meaning of the property. First, you need to know the meaning of the property. Next slide. Next slide, please. So this session, I am going to talk about what is termed as property, then what are intellectual property rights, and why they are important for business entities, different types of intellectual property. This is what we learn in next 1.5 hours. These are the 4 things that we are going to learn in next 1.5 hours. Next slide. Now what do you mean by property? All of you have not raised your hands. What do you mean by property? Property ante enti? Assets. What kind of assets? Lands, buildings. That itself is called property. Okay. Let me ask you one small example. Can a stone on the road be termed as property? No. Very good. Can the same stone in a quarry for which government grants license to excavate, can that be called a property? A licensing right, a lease from the government to excavate that stone, can that be called a property? Yes. So, a stone lying on a road is not called a property. A stone in a quarry for which right is associated is termed as a property. So what is that we are understanding in this? Anything that has some rights associated to it is called property. Say for example this building. Can anybody walk into this building? Yes? Anybody? Why is the security guard standing there? Why is the gate kept? Why is the compound wall kept? To allow everybody and anybody to come into this building? No. Why? Because access to the building is a right given to the owner of that building. If somebody else comes and destroy this property or misuse this property, what your principal will do? He will file a case in the court, right? Similarly, guys, you need to pay attention. Otherwise, if you want to talk among yourself, you talk, I will be sitting here. Okay? So, anything that has associated with some rights, right to own, right to lease out, right to use it, that is called a property. So, you don't have any things which you can say I own it or I use it. Yes, no? How many of you have cell phones? All of you have, right? What is it called? So it's that simple. So everybody will have, there is no person in this world from just born to a person who is going on a deathbed will have properties to them. So it is only that we need to recognize what property it is and how we need to monetize it. That is what we need to learn. So general property, as I given a meaning, that anything that has some rights associated to it is termed as property. And there is difference between regular properties, the properties what you are thinking, and other properties. The property is basically divided into two categories. One is real estate, the other is personal property. What is real estate? Land and building. What is personal property? Your car, mobiles. Your car, your laptop, your phone, all those are regular mobile properties which are called personal properties. Again, this personal property has been divided into two categories. Tangible, intangible. Tangible means those which you can touch, look and see. Look, feel, those are called tangible properties. There are certain intangible properties. Intangible properties are, you can name them, but you can't touch, look and feel. You can't sense it with your sensory organs. Those are called intangible properties. One of the example is, you know all stocks, right? Stock market. All of you know or you don't know? Okay. Stock market, you invested 100 rupees today and after 5 years it becomes 5 lakhs or 10 lakhs. Are you able to see it growing like a building constructed? No, right? So that is one kind of intangible asset. Only your stockbroker calls up and says that no, your property has been increased, or sometimes you invested 5 lakhs, it becomes 5 rupees. It might go down also, it might go up or might go down without you seeing it. So that kind of properties are called intangible properties. And intellectual property is also an intangible property. Intellectual property is also an intangible property which you can't touch and feel. Next slide, sir. So the first thing is, intellectual property protects intangible aspects of it, not the physical product, only intangible aspect. I'll give one example of this to you understand better what is intangibility. There is a professor in famous National Law University and he wrote a book, the book on Right to Information Act. Right to Information Act being a popular subject, he wrote a book and he sent it to publishing to the publisher. When he sent it to the publisher published the book but changed the author name. Authored by not the professor who sent it but another professor name, and book has been in circulation. Sometime later this professor has been asked, like me today, asked to deliver a lecture on intellectual property rights. This professor has been asked to deliver a lecture on Right to Information Act. When he want to deliver a lecture, he wanted to prepare himself better before going to the audience. So he went, searched in library the best book, bulky book and all on RTA Act, took out and started reading it. First page he read, he felt somebody is thinking like me. He has also written same thought process what I wrote in my book, he is also written the same. Second page, third page, everything is same. Then he has seen tables, graphs, everything is same except the first page author name. Everything is copied. Then he took that book and he went to the police station. And he informed the police, my book has been stolen. Police laughed at him. Police laughed at him. You have book in your hand and you are saying it has been stolen. You must be a mad professor. You must be a mad professor and you are saying that it has been lost. It has been stolen and book is in your hand. Then he had to explain, no. It is not a book. It is my copyright has been stolen. Now you understood what is intangibility? It is not the book per se. The book might have been written by you. The poem might have been written by you. But what is protected to you? Copyrights. I'll explain in detail what are copyrights, patents and all. Don't bother about it now. But to understand the intangibility, the machine, the product, what you make is not your patent, not your copyright, not your intellectual property. Your intellectual properties are intangible. Nobody can feel it and see it. It is intangible objects. Whereas our immovable properties like land and building, you can all see and feel it. The second aspect of intellectual property rights is it is limited in term. Protection is only for some time only. It is not forever. If you buy a building, you leave it in, you use that building for yourself, and after your death, your children will enjoy, and after their death, their children will enjoy. As long as the building is owned by you, everybody can enjoy, and if you want to sell it, you can sell it also. However, here intellectual property rights is not like that. Intellectual property rights are protected for limited period of term. After term expires, everything comes into the public domain. That means the property can be enjoyed by every one of you without paying any royalty after the term has been expired. So every intellectual property right has a specific term. We'll discuss in the coming slides what are the various types of intellectual property, what is the term of it. I have given an example for intellectual property as idea behind inventing a time machine. You have seen a time machine? At least in the movies? Yes. So that kind of ideas, that kind of machines can be protected under intellectual property, whereas immovable properties are house or building or car, those kind of things. Next slide. Are you feeling bored or so? Interesting or not? Okay. So the term intellectual property has given to it because the property emanates from human brain. The property emanates from brain. Those who all have brains can create intellectual property. That's simple. So all of you, I'm expecting all of you have brains. Right? Yes or no? So all of you have intellectual property rights. It's only that, like in the beginning I said, who owns the property? Only 2-3 people have raised. Others have not raised their hands. Like that, if I ask now also, who owns intellectual property? None of you will raise your hands. But after my completing my session, all of you will raise your hand, say that we all own intellectual property rights. It's only that you need to identify, you need to pinpoint, this is my intellectual property right. That is lacking. Otherwise, every person who has brain can develop an intellectual property. Next slide. So, anything which is associated with intellect and the property that has associated a right is called intellectual property right. Property meaning anything that is associated with rights. If it attached to intellect, then it becomes intellectual property right. An idea, if you just express it, if you have a wonderful idea and you have written it on a piece of paper, then it becomes copyright. If you have idea in your brain and you have not expressed it, then it is not intellectual property right, it is not copyright. Only when you express it, only when you write on a piece of paper, then it becomes copyright. Innovation, invention becomes patent. An idea with quality identity is a trademark. Idea of external shape is design. An idea which is kept confidential can be termed as trade secrets. All these aspects will go in detail in coming slides. Next slide. Primarily, intellectual property is divided into two categories. One is industrial property, the other one is copyrights. Industrial property because, guys, you need to pay attention to me and not talk to each other. Please. Industrial property means the property which is manufactured, used in the industry. The property which is manufactured and used in industry is called industrial property, and the things which have been created in colleges like this, PEC, or in arts like movies, photographs, those kind of things fall under a different category called copyrights, which is related to human beings, and human arts. So those kind of things are copyright. And then industrial property. Industrial property again divided into patents, designs, trademarks, and GN. Next slide. Now, why are these intellectual property rights quite important to us? Why should we learn intellectual property? All of a sudden, unlike earlier, we have not. This subject is also not in BTech earlier. It was introduced newly. Why is that? Why is that we are focusing now more on intellectual property? The answer is on your screen. We are moving towards knowledge-based economy. Earlier it was natural resource-based economy. Now we are moving towards knowledge-based economy. If I ask who is the richest person 30 years back, not now, 30 years back, richest person in the world. Bill Gates may be richest person because of Microsoft and all that has come in 1980s, 1990s. I am asking before 1980s. Some Saudi king. Why? Because rich oil resources. Rich oil resources, he has become richest person in the world. But thereafter Bill Gates has taken over. Now Bill Gates has been taken over by somebody else. That is because knowledge-based economy. Now if you have 10 buildings, 20 cars and 3 factories, you will not be called richer person. If you have one patent, you will be termed as richest person in the world. The richest person than the guy who has 10 buildings, 10 cars and all. So it is physical property versus knowledge property, knowledge-based property. So now world is moving that way. World has been moved. There are no litigation happening now in the courts for physical properties, because physical properties are already demarcated, countries have been divided, states have been divided, person's property has been boundarized. Everything is done. So no litigation now for physical property. So litigation is now on what? Intellectual property. On knowledge-based products. Knowledge they have been protecting. On that there are litigation happening. That's the reason intellectual property rights which help in technological product, development of technological products, cheaper products, cost of economy-wise cost will be reduced, but high quality, huge profits, high return on investment. All this will be able to be achieved only through intellectual property rights. Next. Now, people like you, students like you, or a startup company, sir was saying that you should all start companies. I wish all of you will have one company in coming future. But what should company do to protect itself? They first need to know what are different types of intellectual property. Unless you know what is this intellectual property, how do you protect it? So first you need to know what are different types of intellectual property, and then file applications before appropriate office for protection of IP. Not just knowing it. First thing is you should know, then you need to list out 1, 2, 3, 4, what are my properties. If you don't register your property, what happens? Your physical property, your land. Land you have not registered in your name. Your father had a land, but after his death you have not got your name registered in the MRO office or sub-register office. What happens? Somebody will come and encroach it. Right? Similarly, for intellectual property also, if you don't register, somebody else will register and stop you from manufacturing that product. Maybe you are inventor. I'll give some examples, you'll understand it better. But must have developed the product, but somebody else filed a patent application, he got a patent. When you want to enter into the market with that product, he'll stop you. So it's better that the moment you identify your intellectual property, you should file an application and protect it. Then enforce their rights in case somebody infringes the right. Somebody copying your work, you should file a case against him. That is enforcement. Then should take care by using third-party products when you are releasing a new product in the market. When you are trying to stop others from copying your product, others will also stop you from copying their product. So you need to be very careful when you are releasing a product in the market, when you are making your project work to submit in the college. Plagiarism. What is plagiarism? You copy paste it, then it becomes plagiarism, right? So that you should avoid. When you want your work to be protected, you should also respect others' work to be protected. You want to copy something, ask that person, I want to copy it and keep it in my project. He'll give a license or he'll give permission, then you can do it. Otherwise you can't do it. Next slide. So sometimes what happens is, you are a student, you got a brilliant idea, a product can be manufactured, but you don't have money. You don't know how it works, you need to test it. So you need to talk to your professor, your person who can fabricate the machine for you. All that you need to do, you need to basically talk to different people, a person who fabricates a machine, a person who tests that machine, a person who gives more knowledge to you. All those people you need to disclose that idea. But if you disclose, what happens? He'll understand your idea and file it in his name. Can that be allowed? So what you need to do is, the best recommendation is, before discussing with anyone, you file your application, get it protected to you. If that is not possible, ask him to sign a non-disclosure agreement, confidentiality agreement. He may be your professor, he may be your friend, but when it comes to intellectual property, the moment you disclose it outside, you lose your rights. So either you file an application or ask him to sign an NDA so that you are protected. Otherwise, your ideas will be going in drain. Or that person, whoever you disclose, he will take your idea and then he will make his product. Next slide. So as I said, the intellectual property, often called IP here it is not Internet Protocol. Intellectual property protects creations of the mind or intellect. IP protection extends to creation which manifest themselves as expressions, innovations, aesthetics, designs and so on. I have given pictorial representation. Expressions, books kind of a thing. Inventions, the telephone, innovations like laptops, and aesthetic designs, jewelry design. Sometimes you girls sitting here, they might do some rangoli and all. Those are really wonderful designs that you make that can be protected. This NIFT and all, what they do? National Institute of Fashion Technology. They make creative clothing with some new designs. What you do on your rangoli at your home, the same thing they will apply to the cloths and they will get protection to it. And people buy the cloths and pay royalty to them. Right? How to make money out of your designs. All that we'll discuss in the coming slides. Next slide. There are various types. This is the first fundamental question. What are the various types of intellectual properties? There are various types: patents, trademarks, copyrights, geographical indications, industrial designs, layout designs and topographies of integrated circuits, plant varieties, traditional knowledge. These are the some of the forms of intellectual property. There are so many, but very important forms I have made here in this slide. Next slide. Read it, please. Maybe you can take this slide into your mind so that you understand what are the various intellectual properties, not just patents. Intellectual property is not just copyrights. Intellectual property is more to it. Intellectual property is copyrights, patents, trademarks, trade secrets, industrial design, geographical indications, plant varieties, integrated circuits and layout designs, traditional knowledge, biodiversity. All this is intellectual property. Next slide. Now what is that you are seeing in this slide? Is it a regular pen? How is it? Generally, how do we write? We hold a pen with 2 fingers. But this guy has made a pen which you can wear it as a ring. You can wear it as a ring and write it. Good olden days. Good olden days, on palm leaves, there used to be a stylus. They used to write like this. With the thumb on it, and then they write with the 4 fingers. That is stylus good olden days. But now, in modern days, we are using the 2 fingers. We will put the 2 fingers and write it. This guy thought differently and made a pen which can be weared as ring. So this thinking process, it is very small. A pen, very small thinking process. Not regular using with 2 fingers. I want to make it differently. Sometimes it becomes, you might think that he is a mad fellow. See, madness and innovation, there is a thin airline difference. Albert Einstein is also called mad for long years until he invented bulb and all, right? So, madness, to think differently. Everybody is walking this way, I want to walk in a different way. So, that is the process of ideation, the process of knowledge enhancement. So, this guy has done this. Next slide. There are several types of intellectual property in this. One is the product itself can be patented. The shape of the product can be registered as a design. And then the name, he has given a name Ring G Pen. He has given a name Ring G Pen. That name can be given protected under trademark. So these are 3 forms of intellectual property rights in one single product. A one single product that has been designed, he got 3 intellectual properties. Next slide please. Patents need not be a rocket science. It can't be laboratory inventions. It can be general thinking. Today you want to go, while going home, you might get an idea. That can be forming a patent. So a zipper, anything you thought, anything you think that can be a better product for humanity, then that can be protected as a patent. It doesn't require rocket science or laboratory experiments. Next slide. Patent protects inventions that are new, useful and non-obvious. Patents are not granted to abstract ideas, physical phenomena, laws of nature. I have given this with pictorial representation. Anything that is new, which is useful, which is non-obvious, will be protected to you. And abstract ideas, an idea behind making a time machine is an abstract idea. It is never completed till date anyone. Unless you concretely say that this machine works, that will not be protected to you. Then physical phenomenon, gravitational force, physical phenomena, those things will not be protected. The laws of nature, like ocean currents, ocean waves and thunder currents will not be protected to you as they are existing naturally. Patent grants an exclusive right to make. This is very important. What patent gives you? Patent gives you right to make, use, sell, offer for sale and import the product into the country. Nobody else, that product which you have invented, the pen which he has invented, nobody else can manufacture without his permission. Nobody else can make use of it. Not only manufacturing, using it. Using it is also not permitted. Selling it, not permitted. Offering, not forget about selling. Just saying that I have this product, I will sell it to you. Offering for sale, that is also not permitted. importing the product into India, that is also not permitted. So these are the 5 rights. When a patent is granted to you, you get these 5 rights: making, using, selling, offering for sale, and importing the product for the purpose of making, using, selling, and offering for sale. So these 5 rights have been granted. When you file a patent application, you get a registration. Some examples of inventions that have been granted patents are electric right, the telephone, etc. Next slide. It's a monopoly right. Monopoly means only you, nobody else. That is monopoly right. Granted by central, it is not state government of Telangana will grant one patent to you, state government of Tamil Nadu will grant one patent to you. It's not like that. It is granted by central government for a limited period of term. As I said in the beginning, intellectual property rights are not forever. It is only for some time. That is only for 20 years. After 20 years, anybody and everybody can use it. That pen, what I have shown in the slide, that is only for 20 years. After 20 years, you all can use it without paying any royalty. Why the patent will be granted to you? In lieu of full disclosure of that invention. You need to provide your knowledge to the society. Society represented by central government will grant a patent right to you for making money out of it. It's a negative right. Negative right is it will allow you to stop all others from entering into that for manufacturing that product or selling that product. You will be allowed to stop all of them. That is the reason it is negative right. It is not positive right. It is negative right. You will be allowed to stop all others from manufacturing, selling, offering for sale, all those things. You will be allowed to stop. That's the reason it is called negative right. It is territorial right. If you have a patent in India, your right is protected only in India. That means people in Pakistan, people in Australia, people in UAE, people in USA can copy your invention. You want protection in those countries, you need to file application in those countries also. Say for example, a US citizen made an invention, very good invention. He filed a patent application and he got a patent in USA. Can you use that in India? Yes or no? Yes. Territorial right. He has not filed an application in India. He has filed application in USA and protected it in USA. He has not filed an application in India, so you are free to copy. So there are several inventions which people feel that a particular territory is not their market and they will not file an application. So those things which are not filed in India and filed elsewhere are free to copy by Indian companies or Indian citizens. So you want to start an industry, you don't have your own technological product, but something else is patented elsewhere. That machine you can copy, manufacture and sell it in India without paying any royalties. This monopoly, as I said, this is a monopoly right. This monopoly ceases to be existing after 20 years. Next slide. Next slide. Next. See, the object of patent system is to encourage inventions, to make more and more inventions disclosed by you, and to breed inventions, to keep database of inventions, so that what is happening in the technology today, automobiles, what is the pace of automobiles? Driverless cars. We are able to see automobiles coming as driverless cars. So what's happening in automobile technology? You want to know, when you see the patents, you will get to know how technology is pacing, where it stands today. Where technology stands today, you will be able to make out by seeing patents. Till date, what has been developed, where the technology stands today. You want to check it out, you just see the patents, you will get to know. To update industrial development by working of patent inventions on commercial scale. Not just granting of patents, but ensuring patents to be manufactured in the industry. Working of it. You have an idea, you patented it. Once you patent it, it doesn't end there. You need to manufacture the product and supply the product to the people. That is what is called updating industrial development by working of the patents, working of that inventions, and on a commercial scale, so that you make money and make product available to public at large. Then avoiding reinventing of the wheel. Wheel has been already invented. If you are putting R&D money to again invent the wheel, it is nothing but you are wasting your time and resource. So, whenever you want to do some R&D, whenever you want to see all your young brains, you want to do your, at least your PEC final year project, you want your own idea should go in, right? So when you want your own idea should go in, you need to check what is already existing. If you invent something, maybe some invention you have come up, which is already there, then can it be termed as your knowledge or somebody else? It is already filed by somebody else. Somebody else already registered it. If you generally come up with that idea also, it is without seeing him, you have developed that idea also. People say that it is copy of that. They will not say that it is your own. That's the reason the patent system has been designed in such a way, the database has been created in such a way that you will get to know what's happening in the technology. When you get to know what's happening in the technology, after this what I can do. Till here the technology has been developed. After this what best I can do. How I need to simplify this. All that you will get to know by reading patent documents. Next. Next. If you see Nokia, a world famous company which is into mobile manufacturing, right from the Talkman, Cityman, Walkman and several models. Hope all of you have witnessed this. Yes or no? Until Samsung and Apple and recently the Chinese companies Xiaomi or Realme, whatever it might be. So until they have captured the market, Nokia was world leader in mobile technology. Why? That happens because innovation is the real contributor to the competitiveness. The moment you stop innovating, you will perish from the market. You will not be there. To exist in the market, you need to innovate. You need to come with new and new products and file patent applications regularly. Next level. Now I'll give you one good example by which you understand why patents are quite important. You all know this company called Kodak? Yes? No? Kodak, what is that company about? I want answer from the audience. What is Kodak company? Cameras. Okay. Kodak company was manufacturer of cameras and it is one of the multinational company. It was a very big company, but it is no more now. The company has died. Bankrupt. The company has become bankrupt. Why would have that big company, worldwide sales, big company, big name has died? What would be the reason? There are several reasons. One reason is the manual cameras gone and we have now digital cameras and all. That is one good reason. But for the death of Kodak, it is not that reason. Kodak has invented, like Nokia, Kodak has been going on inventing products and releasing in the market. They released one product called instant camera. You all know instant camera? The moment you click, you get the photograph. The moment you click, you get a print of that photograph. So that is instant camera. So they invented that and they released it in the market, not knowing Polar ID has a patent to that. Polar ID is another company which filed a patent application for that instant camera and got a patent protected to itself. When Kodak has released it and selling it in the market, Polar ID filed a case against Kodak and court awarded $935 billion. $935 billion. By paying that $935 billion to Polar ID, Kodak became back. So once a world famous company, big company that has died because of simple reason that they have not filed their patent application, that they have not bothered to check whether somebody else has a patent or not before releasing the product in the market. So when you want to release a product in the market, you need to cross check. In simple terms, I don't want to complicate it more. When you want to submit a project report to your professor, the simplest thing is, before submitting it, you need to do a plagiarism check by yourself before it goes to the market. So you need to check whether he has already, are there any copyrights to this content, are there any patents to this work, is what you need to check before it released in the market, before you submit the project to the professor. Right? So that mistake they have done, they have paid for it. Next slide. Copyrights. So you have any questions to me on patents? You want to know anything more on patents? If you have an idea what you need to do, you need to keep it secret until you file patent application with the patent office. If you are able to file it on your own, there is a portal called ipindia.gov.in. On that portal you have some guidelines also, you can file it on your own. Otherwise, consult a patent attorney who will help you in filing the patent application. The fee is very small. If you go to a restaurant, how much will you do? Around 2,000, 3,000 rupees. One meal with your friends and all. To file a patent application, it is 1,600 rupees. 1,600. Just 1,600, if you file a patent application and get your idea protected, that can make more revenues to you. I'll give another example of how a small invention has generated revenues for a person. You all know about this Coca-Cola tin opener, right? Automatic. The moment you click it like this, it will open and you can drink the juice. You all know about that tin? Yes, no? So this guy who invented the tin opener, he had been approached by Coca-Cola company. Coca-Cola company said, I'll pay you 10 crores. You give that invention to me. We'll use it for our products. This guy said, no, I will not give. I will not sell my invention. He said, I'll license it to you. One tin, 1/10 of penny. 1/10 of penny means 1 rupee, 1 paisa of 1/10 paisa of 1 paisa. That means if they make 100 bottles, they need to pay 1 rupee. This fellow laughed, this Coca-Cola CEO. I am saying I will give you 10 crores, you are asking pennies, 1 penny, 1/10 of penny. He signed the contract. Then first day manufacturing of that product, 1,48,000 pounds, UK pounds, has been paid as royalty. First day. Like that every day for 20 years. For 20 years every day, 1,48,000 pounds. Say for example in Indian currency 1,50,000 rupees every day. What is the invention? Very small. Does it require rocket science? It's very simple invention. Not just that, Coca-Cola is paying that. Then Pepsi-Cola approached. Same principle. I will not sell my invention. You also manufacture. Pay me 1/10 for every can you manufacture. So Coca-Cola paying 1,50,000. Pepsi-Cola paying 1,50,000. Every day 3 lakhs. Which profession or which job will give you 3 lakhs a day? Tell me. Is there any profession which gives you 3 lakhs a day? So now how serious you should be about patents? If you study 4 years, after that 1 year or 2 years for searching job, and after that you place somewhere, how much you will earn? 1.5 lakh per month, not per day. But this guy, Coca-Cola guy, this guy is made a small invention, very small. Every day he is getting 3 lakhs, 1.5 lakh from Coca-Cola, 1.5 from Pepsi, and he is not sold that invention. He has licensed it. Some beer companies have come. Some medicine companies have come. Everybody said, okay, same principle, 1/10 of the penny. Everybody. And everybody is paying. For how many years? 20 years. Every day, 20 years you are making money. You can rest of the life, you can enjoy. Right? So that is the powerfulness of the patents. Now I hope you understood the importance of patents. If you have any questions, you ask me now. Otherwise we will move on to copyrights. Yes, no? Evakana questions unnaya? అర్థమైందా? అర్థం కాకపోతే ఏముండవు, అర్థం అయితే ఏముండవు. Questions. What should I feel? You completely understood it or you completely it gone over your head? Is it completely understood? Very good. So what are the requirements for filing a patent? What are the requirements for filing a patent? Somebody who said completely understood. It should be new. I have given in the previous slide. Can you go back 2 slides? Go back, go back, go back, further back, back. What are the requirements? It should be new. New in sense that product what you have invented should not be existing in this world till date. It has come out of your brain. If it is existing in USA, it is already existing product. It should be a new product, like a pen you have seen. Regular pen is there. Ring type pen is not there. So that is newness. Then the next requirement is it should be useful to the public. Usefulness in sense, if you have made a machine, but you can't make a second machine like that, there is no usefulness of your invention. You should be able, the invention what you have made should be able to be repeatedly made in the industry. It should be repeatedly able to made in the industry, then only it is qualifying usefulness requirement. Then non-obviousness. What is non-obviousness? As the word itself, it should not be obvious to persons skilled in that. It should not be simple. I'll give one example for this. There is this product called mobile phone, Nokia mobile phone, you all seen, right? And there is digital camera already existing. Somebody developed a smartphone. When you are checking for novelty, newness, what examiner will do, the patent examiner, when they want to grant a patent to you, they will check whether it is new or not. When they are checking whether it is new or not, guys, please, this area, please don't talk among yourself. You can ask me questions, guys. So when patent examiner is checking newness, till the smartphone's newness, he will check, is it similar to the regular Nokia phone? No, it has camera inbuilt in it, different. So it is new. Then he will compare it with digital camera. Digital camera is also existing, but it does not have a communication tool. So smartphone is new. The examiner says having mobile phone and digital camera will not negate the smartphone from getting a patent. That is new. He will qualify the requirement of newness. When it comes to non-obviousness, he will combine these 2 documents. Mobile phone document and smart camera document. These 2 combination, he will read it. And what is a smartphone? It is nothing but clubbing it together. Right? Anybody can think of, there is mobile phone existing, communication tool is existing, digital camera is existing. What is it? Smartphone guy did? He combined these 2, put a rubber band to it, becomes smartphone. Put a rubber band to it, becomes smartphone. Is it that simple? If it is that simple, you won't get a patent. If it is not that simple, then it qualifies non-obviousness requirement. All of you understood? Now what are the requirements for grant of a patent? 3 things. New, useful Non-obvious. This is called none test. None test. N-U-N. New, novel, useful, non-obvious. Novel, useful, non-obvious. Next line. Copyrights. That. Copyrights. This is very important for you all. Copyright. I must say, copyright is protected to expression of ideas, not ideas per se. Even if you have wonderful idea, but if it is not expressed, that will not be protected to you. That is what this theory called idea-expression dichotomy says. Idea-expression dichotomy means ideas are not protected to you, only expressions are protected. Now, the story of Ramayana, who is written first? The epic story of Ramayana. Valmiki. After him? Anybody wrote it or not? Tulsidas. Did he write? Somebody else. Recently some movies also came. Sri Ramdasu or Ramanand Sagar made a TV serial. So there are several same story but different expressions. Everybody has a copyright. The story of Valmiki is not copied by Tulsidas or Ramanand Sagar. The story of Valmiki is protected to Valmiki. The way the Ramanand Sagar made a TV serial, that is protected to him. The way Tulsidas wrote the Ramayana as a poetry, that is protected to him. So what is protected here? Is it the central idea of Rama, Sita, Lakshmana in the story, or the way it has been written? If you understand this, your projects will not be caught up plagiarism. You understood this point. So what is protected is what expression given by you. So if you want some content for your project from internet, you Google it and you get some content. Instead of copy pasting it, try, read, understand, rewrite it in your work. That is allowed. It is not plagiarism. Read, understand, rewrite on your own language, on your own way. That is allowed. That is a different copyright. You will get a copyright. Whatever you expressed, that is your copyright. You understood? Yes? No? Idea is not protected. Idea is open for everybody. Idea is open for everybody, and what is expressed to you, that is protected. For getting a copyright infringement, the person who alleges infringement should prove that verbatim his content has been copied and pasted. So that is what idea expression dichotomy. So to get copyright protected, you need to express the idea on a tangible form. It is in my brain, sir. It is in my brain, sir. I thought exactly same words. Everything is same, but I didn't write. He has written it. Whoever has written it, he will get copyright. Since you have not get it out of your brain, it will not be protected to you. So it needs to be on a tangible medium. Tangible medium means it can be a piece of paper, it can be a magnetic tape on computer, you can type it. All that is tangible form. So some tangible form, you need to write that work or express that work to get copyright protection. There should be originality. Now what is originality? There are 10 books. Each book, one chapter, I will tear it off, put it in my book. Can that my work be called original work? Yes, no? There are one chapter otherwise. There is one chapter, 10 people have written that one chapter differently. Each one of them have written it differently. 2 lines of each of them, I will compile them and I will say that it is my work. Can I claim copyright to it? No, because it is not original work. Original thought process has to be gone into your work. Whatever you have created, your thought process, your expression should have come in. Somebody else's expression, if you copy and paste it, that doesn't become your original work. Then modicum of creativity. To get a copyright, there should be creativeness. Unless you are creative, you can't write any work or you can't make any painting. So you need to be a bit creative. However, there are artists who call a artwork as modern art. They throw some paint on the canvas and they say that it is a modern art and they sell that thing. So modicum of creativity is at a lower pedestal. It is not, even if you write something, me creative working. Chatta story there are people. Now copyright is also attributed to the person's character. What are called copyrights are two kinds of rights untai. Economic rights and moral rights. Copyrights, there are two kinds of rights, economic rights and moral rights. Moral rights reflect the character of the person. The moment I say Ram Gopal Verma, what do you get into your mind? Romantic movies, horror movies, movies which has involved controversies. I will talk about Gautam Menon, love stories. So the person's character is reflecting. By taking his name, you are able to say that what kind of works he has created, right? So that kind of things are called moral rights. His character is reflecting with that. So what are the subject matter? Literary works, musical works, photographic works, sound recording, dramatic works, artistic works, cinematographic films. All these are protected under copyrights. However, you need to remember, in case of independent creation, say for example, maybe your friend and you studied in this college for 4 years, after that you went, one girl went to Australia, one girl went to America. And both of them want to write a short note on how PEC was. Pallavi Engineering College, how it had treated them and all. Both of them have written a book about starting from the day one, how she has entered in the college, what happened, how teachers have taught, until leaving the college. She made a 260 pages or 300 pages book. Both of them have made the same book. Word to word, everything is same. Coincidentally, who should be given copyright? Who should be given copyright of that book? Forget about that book. The seminar is happening. Some of you wanted to capture pictures. You stand it here, same angle, photographs. Two people standing in same pose, same angle, they took photographs, same photograph has come in. Who should given? First photographer or second photographer? Who should be given copyright? Who? First photographer? The person first clicked. Think that both of them clicked at the nick of that second. Now tell me. Who should be given copyright? Both of them will get copyrights against the word. So they can stop all others using that photograph without their permission. So how many of you have clicked photographs till date? How many photographs have been clicked by you? Raise your hands. None of you have clicked any photographs on your mobile phones also. None of you have Facebook accounts. None of you have posted your selfies. Yes, no? So all of them are what? Your copyright works. You have any properties? That is your work. Now I will give you an example. What happened in Bangalore, when I was in Bangalore, we went for a team out. I think that is Barbecue Nation. Hotel name is Barbecue Nation. We had food. Then the waiter got us desserts. Desserts were so nice, eye-catching. So we took a picture. And one of us is a blogger. He wrote a blog saying that we went to the Barbecue Nation on so and so day and we had this food and all. He has posted those pictures on the blog. There is one magazine, I don't want to name the magazine, but the magazine has copied this picture in their food article. They have wrote an article on a food and they captured this picture and printed and published. Unfortunately, that magazine came to our office we have seen that the moment we see, we recognize that it is our picture. And you know, we are intellectual property lawyers. We have not spared him. We sent a legal notice. We sent a legal notice asking him to say why you have copied our work without our permission. Then he apologized. He paid some amount which has taken care of the entire bill amount of our treat. And he also said that henceforth I will not do this. He has given an apology letter. There ends the matter. We didn't take it to the court. We said that that's okay. You have paid some amount and you have apologized us, that's okay. So that is the importance of a picture. Why I am narrating this? We have our team has 20 people, and barbecue innovation, you know how much it is. 20 people into that amount we have received. So that is the importance of copyrights. If your work has been copied by somebody, you should also say the same thing. You should also do the same thing to get that money back. Next slide. Next slide. Now the term of copyright is unlike patents. Copyright has longer duration of term. Term of copyright is lifetime, previous slide. Lifetime of author plus 60 years. Lifetime of author plus 60 years is the protection. That means if I clicked a photograph here today, throughout my life, if that photograph has to be used by you, you need to take my permission. Otherwise, after my death, my children, till how many years? 60 years. All those works which are prior to 60 years of death of an author, those will come in public domain. Can you give me one or two names of a movie or some work which is in public domain? 60 years before. All of you watched Walt Disney's cartoons, right? How many year old? How many year old this Walt Disney's Mickey Mouse? Mickey Mouse you have seen? So Mickey Mouse, and there are today now I think it is all Doraemon, not Mickey Mouse. But earlier it is all Mickey Mouse. So 60 years is crossed. You can play it in a theater. You can play it in a theater, charge the ticket for it. You don't require to pay any amount to anybody. Walt Disney, you don't require to pay any amount. Because it has come in public domain. That is, everybody is free to copy that. For cinematographic films, for books, for literary work, artistic work and musical work, it is from the death of the author 60 years. For cinematographic films, it is from the date of release 60 years. That means 60-year-old movies, any movie you are copying, there is no royalty required to be paid. No royalty required to be paid for movies which are older than 60 years. Now I will tell you how to monetize this. You all know YouTube channels. YouTube channels, you all know about it, right? So, one of my clients is a very big company. What he did is, he purchased around 2,000-3,000 movies from different producers, from different languages. And what he did is, he posted all those movies on YouTube. Not only that, he made some clips out of it, comedy clips, then fighting clips, romantic clips. There are different clips he has made. He posted them also on YouTube, as well as he sold it to telephone vendors like Airtel, Jio and all. All of them he has sold. So, every month YouTube pays him around 60 lakh rupees. Every month YouTube pays him for 2,000 movies what he has posted on YouTube. YouTube is paying 60 lakh rupees to him. Now, if this 60-year-old movie have been made by you start a YouTube channel, post the 60-year-old movies which will be in public domain anyways. You figure out what all movies cross 60 years, post that movies on your channel and you will be getting revenues. If people watching your videos, you will get revenues. Free of cost. It is only that you need to identify and post it. Maintain that channel. See, 60 lakh rupees is not a small amount, right? So that kind of revenue you can generate if you want to monetize the older versions which are public domain, that can be used by you. Next slide. So it can be, copyrights can be for your coding software. Like you write poems, you also code computer programs to design. That you will be protected under copyright. The music, lyrics, as well as the musical tone protected. The creative artistic works, including computer graphic designs, are protected under copyrights. Next slide. What rights you get? Right to reproduce, right to adapt into a different movie or product, right to distribute, right to make derivative work, right to make public performance, right to make public display, right to translate into another language. All these are called economic rights. Next slide. You all got to know what are copyrights? Yes, no? How to make money out of it? Yes, no? Very good. Now the next thing is trademarks. You all know the famous trademarks. Citibank, LG, McDonald's, all these are famous logos. The moment I say Citibank, what is the service or product these people will do? Banking service. What is LG? Consumer electronics. What is McDonald's? Food. So the moment I didn't even say who is the owner, what they do, nothing. I just give a name. Automatically you are saying what product or service they are doing. So today it is based on the brand name. There are four shoe brands I'll give. Nike, Action, Puma. So the moment I give this name, you know the quality also. Bata, Nike, Puma and all this. The moment I give the name, you get the quality to associate to it. So the quality and the source from where it is coming, which business house it is coming, that is protected under trademarks. Subject matter is representation of your business. Term is, unlike patents and copyrights, term of protection for trademarks is unlimited, subject to conditions that you need to use and renew the mark for every 10 years. Initially the protection is granted to 10 years. Every 10 years you can renew it. As long as you use it, it will be protected to you. If you don't use it, that will be lapsed. Say some cool drink brands. You know this Gold Spot. Is it existing in the market now? Since it is not being used, it is expired. What are the requirements to get the protection? Distinctiveness, it should be different. Distinctive means it should be different. There are hundreds of brands in the market. Guys, I bet you that you will repent if you have not listened it properly. మీరు రేపు పొద్దున స్టార్ట్అప్ కంపెనీ పెట్టుకున్న తర్వాత ఇలాంటి సెషన్కి మీరు లక్షల్లో పే చేసుకోవాలి. కాబట్టి కొంచెం జాగ్రత్తగా ట్రేడ్ మార్క్ అనేది చాలా ఇంపార్టెంట్. ఫర్గెట్ అబౌట్ ప్యాటెంట్ బ్రెయిన్తో అదేంటి ఇన్వెంట్ చేయాలి. యూ నీడ్ ఇన్వెంట్ టు గెట్ ఎ ప్యాటెంట్. For getting a copyright, you need to make a creative work. For trademarks, you don't require to be inventive and you don't require to be creative. Whatever name you give to your product or service, that is protected as IP, intellectual property. So what it is requirements are, it should be different. Distinctive means different. There are 100 soaps in the market. Lux, Synthol, Margo. There are 100 soaps. You are 101 company coming in the market. It should not match with this 100 names. Patanjali soap. Is it matching with the rest of the 100? That is a new name. If it matches with them, then it will not be protected to you. That is the first requirement. The second requirement is, it should not be deceptively similar, confusingly similar. It should not confuse public in the market. The moment you say for example, RIN soap is there. RIN is RIN. Instead of RIN, you put RUN, same blue color, same violet blue color, same lightning ray, everything is same. Instead of RIN, you put RUN. You are a new company, RIN is already existing. What is that you are trying to do? You are trying to confuse people. So deception is not allowed. It should be different. It should not confuse public. Those are the only two requirements for getting a trademark grant. Next slide. There is what is called distinctiveness ladder. Justice Friendly in Abercrombie case has propounded this distinctiveness ladder for trademarks. What he said is coined words are, which does not have English dictionary meaning, or fanciful marks. Fanciful marks. Kodak. There is no meaning to the word Kodak in English dictionary. You can't find it. That's the reason I suggest all my clients 2 letters of your name, 2 letters of your wife's name, 2 letters of your daughter's name, 2 letters of your son's name. That becomes a coined word. Ajinomoto. Does it have any meaning? So that becomes a brand. Xerox doesn't have an English. Now it is replaced photocopier as Xerox. But earlier Xerox is a coined word. So like that, coined words are called fanciful marks. Then comes arbitrary names. Product is different, service is different, name is different. Apple for apples would become generic. Apple for apple would generic. But Apple for computers is arbitrary. Apple for apples is generic, but Apple for computers is arbitrary, will be protected. Apple for chairs, Apple for projector is a different, it is not connected. Apple is not connected to projector, Apple is not connected to chair. So those are arbitrary marks. Those are also more distinctive and you can adopt those names. Then comes suggestive marks. What is Infosys? Infosys has 2 words. Information systems. Sliced into 2 halves. Info and sys. It combined. So what they do, Infosys people, they work on information systems. You require little mental effort for understanding the word and understanding the product or service. Those marks are called suggestive marks. Suggestive marks are also considered to be distinctive and will be protected. But thereafter, descriptive marks, the mark which describes the product or service. The mark which is generic, which is the name of the product itself, will never be protected to you. To get protection, it should be more distinctive, it should not be less distinctive. Next slide. What you get once a trademark is registered to you, exclusive use of the mark. That mark, you can alone, Apple company alone can use it. Nobody else is allowed to use Apple for electronics. If somebody starts using Apple for electronics, what they do? They file a case against them. Claim goodwill and associated reputation to it. If your product is too good, like when I said Nike, Puma and Action and Bata, you get some quality associated to it. That is because of the brand name, that goodwill and reputation is associated to the company. Next slide please. This Google, now the search engine has been, the moment I say search engine, you will get 3 or 4 names. What are those 3 or 4 names? Computer science students. Google is 1, Bing is 2, Yahoo is 3. There are some names, but lastly it is Google. Now Google, anything you want to search on internet, you use a keyword on Google to get the results. So what it did is, it started selling the AdWords for companies. It started selling AdWords to the companies. Companies are buying the names and then advertising their websites. One example is this Sapna Book House. Sapna Book House is very famous, popular book house in Bangalore, which sells law books. Sapna Book House, it sells law books. Now Flipkart initially it was not selling all the products. Initially they were selling only books. Flipkart started its business with selling books. So what they did, they have used the Sapna Book House name as an ad word. They have used the Sapna Book House name as an ad word, and whoever searches for Sapna Book House, Flipkart website used to come up, and those people, instead of buying books from Sapna Book House, they used to buy books from Flipkart. So that is what happening. So there were several cases filed around the world against Google for misusing brand names, misusing trademarks. Likewise in Bharat Matrimony, Shadi.com or Bharat Matrimony, they have used the same name for another. The Bharat Matrimony has been purchased as AdWord. When Bharat Matrimony is typed, Shadi.com used to come, the website link. So people used to get confused and went to the other website. In fact, it happened to us also. When I want to travel to Malaysia, immediately what happened on that time, until I was planning to travel, it was fiscal visa. I need to go to Malaysia embassy and apply. But when I have decided to travel to Malaysia, Malaysian government has announced that Indians are eligible for e-visas. That means you can just type in website and get a visa. So I searched for Malaysia e-visa on Google. Then immediately I got a link. Generally the first three are ad links. You should not go to that first three. Then only you will get to right link. But as usual, others I have also clicked on the first link. The website came, all Malaysian flags and all on the website, which I felt that it is genuine Malaysian website, and I pay. It has all details, my passport number, my date of birth, my father name, everything I have given, and it asks payment. I clicked on the payment. It didn't say how much amount. You give your credit card details. I gave him credit card details, and I got $150 as the bill. Once I got done, I want my wife also travel along with me. So I have filled her details, I gave her $300 gone. Then I thought, US is a big country. The visa fee for US at that point of time was 9,000 rupees. What is $150? $150 is more than 9,000 at that point of time at least. So I got, Malaysia is a small country, it should have small visa fee. Why more than US? I called up. They said, the website people said, sir, the visa fee is only $10. $140 is our professional fee for processing it. To guide you and process you, we are charged $140. Had I been gone to official website and booked the visa, I would have paid only $20. $10 for me, $10 for my wife. Now I have paid how much? 150, $300. Out of $300, $280 extra. $280 have been cheated because of AdWords. So that is the importance of AdWords and trademarks. If your brand is not registered, what Google has done, everybody is filing cases on Google for selling AdWords. Google has come up with an intellectual property policy. They said, if a trademark is registered, we'll withdraw that mark from the AdWords. That means if Sapna Book House has been registered as a trademark for them, they will withdraw it from the AdWords. That means if anybody searches Sapna Book House, only Sapna Book House website will come. The other websites will not come. The other advertisements will not come. That is the policy taken by Google to save their skin. Otherwise, everybody will file a case, right? So that is the reason that policy has come up now. Next slide. Industrial designs. I am saying you are all exhausted. However, I will discuss this and stop it here. I have another 20-30 slides, but I don't want to run all of them. I will talk only on industrial designs and stop it. So industrial designs is for any product. The selling of the product happens only when it appeals good to the eye. It's like even food. If food you see looks like dirty, will you eat that food? Black color some dish is there. Will you touch it? No, I don't want. So anything which is eye-catchy, you purchase it. You eat that food or you purchase that product. So industrial designs are shape of products. It can be a mic shape, a chair shape, a shape of this ornament or projector shape, any shape. Any shape is protected under industrial design. It should be new, it should be original, it should be ornamental, it should not be functional. If it is functional, functional means, suppose this mic has a better grip. I have made a design to have a better grip. Then what I am doing here, I am giving a functionality here. Functionality will go under patents. I have made some lines here. 3 lines, 4 lines like this. To become eye-catchy. Then it is industrial design. So if there is functionality, if you have created a design for a purpose, for a function, then that is a patent, not industrial design. Only when you make a design for eye-catchiness, then that is called a design. So designs will be protected only when it is ornamental. It can be a car design, it can be a Coca-Cola bottle design. Next slide please. Trade secrets, I don't want to discuss because you are all exhausted. Next slide. Next slide. Integrated circuits, the chipsets within this. This mic is working because there are some chips inside this. The chips which make this mic function are also protected under a special act called Semiconductor and Integrated Circuits Layout Designs Act. Under that it will be protected. New designs, again same principles, original design, different design. It should not have been gone in the market before you file application. Next slide. Geographical indications. It is a community trademark. Group of people of particular locality are manufacturing a particular product or providing a service. For example, Pochampalli saree. Pochampalli saree is a saree that is being produced by people in the Pochampalli region. Ikkat we call it. So those kind of things which originate from a particular place, identity to that place, and quality and reputation, other characteristics are connected to that place, then that will be protected. The protection is like trademarks, it is unlimited. Initially 10 years, thereafter every 10 years it needs to be renewed. Next slide. There are several GIs. Basmati rice, Darjeeling tea, Kanchipuram silk saree, Alfonso mango, Nagpur orange. There are several like this. Next. Apart from these IPs, traditional knowledge, biodiversity are other forms of intellectual property. Next slide. Next. Further more. More down. I don't want to discuss because paucity of time. I don't want to discuss all this. Next. This. Can you tell me which is not protected under patents? What is protected for crops? Hybrid plants, hybrid crops. You are right. Phone, car, or cigarette are protected under patents, but crop is not protected. Crops are also protected under a separate law called Plant Variety Registration. PVPFR Act, there is a separate act under which plants are also, hybrid varieties of plants are also protected. Now this is your turn. Question and answers. If you have any questions, you can ask. Yes, IPR is not a subject which can be taught in 1 hour or 2 hours. It requires a lot of, every topic in itself, I can at least talk about half a day or 1 day, entire, only on patents I can talk about 1 day, only on copyrights I can talk about 1 day. Next slide. Thank you all.
I should thank students for being patient. I know it is very humid here. I know I trouble you a lot, but it is for your sake, okay? Because in the coming future you will be somewhere in your career. So you should have an idea about what is a patent, what is copyright, what is trademark, and how you should file a patent, and how you should protect yourself from being trapped. Okay, your ideas, I mean. Thank you, my dear students, for being patient. Is the session valuable or not? Did you enjoy the session? About the atmosphere, you leave it. About the content, is it valuable or not? Thank you, Vijay Kumar sir. Now it's time to felicitate today's speaker, Mr. Vijay Kumar Garu. I request our principal sir, heads of the department and other senior staff whoever are available, please join for the felicitation. I request Vijay Kumar sir, please come onto the dais. Please give a big round of applause. No energy.
ఫోటో ఉంటుంది. నేషనల్ అని పెడతారా? పెట్టండి యూట్యూబ్లో.
We'll end up the session with national anthem. Please stand up. Keep quiet.
సార్ దొరికింది. అదే
मनी का पर्सनल लोन है
अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तव जय गाथा जन गण मंगल दायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे.
Yeah, you can disperse. I once again express my sincere gratitude to today's